Well, good afternoon, and thank you so much for coming to see us this afternoon. Obviously, the whole question of the veto has been quite a big issue in much of the consultation. But just to get things rolling, do you want to make an opening statement yourself, or are you happy for us to ask you questions?
Thank you very much. I think I'm very happy for you to ask questions. I don't think I've got any particularly sort of profound pronouncement to make on this subject, but I'm very happy to help you with your work.
Okay, thank you very much.
Mr. Grieve, on the 16th of October 2012, overriding a decision of the Upper Tribunal on the 18th of September 2012, you exercised the veto to prevent the black spider letters of the Prince of Wales being released. Would you like now, looking back on that, to give us your assessment of how damaging or not was the publication of those documents? And perhaps if you do regret the decision you made, perhaps you'd tell us.
I don't regret the decision I made at all, and if I had to make the decision again today, I would make it in exactly the same terms as I made it at the time. Just to sort of go back a little bit, obviously my role in this process came about because although the government had objected to the publication and had taken the matter to the tribunal, if there was any question of the exercise of the ministerial veto, it fell to me as Attorney General to do it because it concerned the papers of a previous administration. So it was for that reason that it landed on my lap. And I have to say that when I read the decision of the upper tier tribunal, I'm sure well-reasoned and well-intentioned as it may be, I disagreed profoundly with it. I thought the reasoning was, frankly, very seriously flawed in its assessment of the public interest. And that was my view. Of course, there was a consultation process which then took place within government, as is required, and as I'm sure you're aware, right through the Cabinet Office, as to what other people's views might be, but ultimately it was my decision whether or not to exercise the ministerial veto or not. And I chose to do so. I mean, the reasons, in a sense, I gave in the reasons which were set out at the time. Perhaps just to try to encapsulate that, it seemed to me that by virtue of what I think is known as the educational convention, by which the heir to the throne is educated in the role of becoming king, he has access to government papers, which are provided to him for that purpose. And in addition to that, he also performs a huge range of public functions where he goes around the country and people impart information to him. So it places him, just as indeed it does the monarch, in a unique position to have both an understanding of what some of the background to issues may be, because the government papers are available to him, and also, I think it's fairly obvious, a pretty clear ability to get an understanding of what people think about various policies. Now, in those circumstances, it seemed to me, is it in the public interest that he should be able to communicate what he has learnt from his own activities to government ministers? And the answer to my mind is overwhelmingly that he should be able to do so. And he can't do that unless it is within a degree of confidentiality, because the very nature of his role means that he shouldn't be taking a partisan approach in public, but he's perfectly entitled to impart his own ideas as well as passing on the concerns of others in correspondence that he might wish to have with ministers. And that would be prevented if the letters were published. Now, in actual fact, as you'll be aware, we've changed the rules. So for the future, the Prince of Wales's correspondence as heir to the throne is protected under an absolute exemption. So we were in one way dealing with what were historic documents, and to an extent what happened there was a bit of a one-off. But for all that, it didn't seem to me that the principles involved in all this were any different. And that was why I exercised the veto, and I would do exactly the same thing today.
Well, thank you for that very clear explanation. It follows from what you've said that it's your view that the government should have the power, should continue to have the power to veto decisions of tribunals and the courts, given the decision of the Supreme Court, insofar as one can deduce a single decision from it. Is it your view that there should be further legislation to clarify the circumstances in which the veto can be exercised?
Well, here I think we move into a slightly different area. I had to apply the law as I understood it to be. And certainly my understanding was that Parliament had expressly provided for a ministerial...
Are you okay?
Yeah, I'm fine. It's just announcing the start of the day's business. I don't think anything more significant than that. It was certainly my understanding that Parliament had expressly provided in Section 53 for precisely such a ministerial override. Now, obviously, I've taken great interest in the Supreme Court judgment and indeed that of the Court of Appeal which preceded it, even though by the time we got to the Supreme Court I was no longer in office. The Supreme Court, as you'll be aware, were kind enough to say that they didn't think that any of my reasoning was unreasonable, but they thought that I had exercised my reasoning wrongly because I failed to understand the extremely limited scope which that reasoning was in fact going to be allowed. If you read Lord Neuberger's judgment, which is a lead judgment, he makes quite clear that he thinks the interpretation of Section 53 is extremely narrow. And the point which he made, and which clearly shines through the judgment, and I think that of the majority, was their deep concern at what they saw as, I think, a constitutional, I'm not sure the best way to describe it, but a constitutional insult, I suppose might be the way of describing it, that we should have a situation where a Minister of the Crown could, by veto, override a superior court of record. Now, it seems to me there's a bit of an irony about this, because Jack Straw will know more about this than I do, but it's quite clear that, of course, when the Freedom of Information Act went through Parliament, the original idea was that the tribunal was going to be merely advisory. Parliament, in its wisdom, decided that in many cases it would become mandatory, but wanted to provide a ministerial override, and I don't think anybody really focused at the time we did this on whether we were perpetrating a constitutional enormity which was to give a Minister of the Crown the power to override a superior court of record. So I am actually not unsympathetic to the view expressed by the Supreme Court, even though I found their interpretation of the clear terms of the statute somewhat surprising, that of the majority. I'm not unsympathetic to the Supreme Court's view that it's not the happiest place to be. It seems to me, therefore, that if we are to restore the ministerial veto, because it's effectively been destroyed by that judgment, yes, then it would probably be sensible to do it in a way which perhaps puts the question as to the way the government wishes to approach this back to an earlier stage, so that we don't have a situation where we have ministers exercising ministerial vetoes which override the decisions of superior courts of record. And I think that could probably be done. Of course, it's up to Parliament. If Parliament wanted just to come back and say, if you didn't think it was clear enough originally, we're going to make it clearer to you this time round, yeah, it is undoubtedly within Parliament's power to do that.
On this point, and it's a very helpful answer, the Information Commissioner last week suggested to us that the veto should be limited to overturning his decisions, so there would be no question of the Attorney General or any other minister overturning a decision of a court of record. Now, leaving aside issues of the separation of powers, which may be relevant to your point, would you support the view that the veto should be limited to the Information Commissioner's decisions? And could you see any difficulties from exercising the veto at that stage?
The difficulty is this, isn't it? That, and I think this was quite apparent during my time in government, that once you have a system which provides for a review by a upper tier, by a tribunal, ministers, far from being gung-ho about exercising the ministerial veto, tend, on the whole, not to want to do it unless it's absolutely necessary. So, as I could see for myself, not just with this example, but there were others when I was in government, there was a strong and, to my mind, entirely understandable view, well, we should exhaust the tribunal process first because we've got a good argument and therefore we should wait to see whether the tribunal, surely the tribunal's going to agree with us, which of course takes a bit of the heat off government ministers of then being seen to veto a request for information which may be exciting quite a lot of public interest. And so as a consequence of that, I think I could see during my time in office that a trend was developing where the ministerial veto was only being used as a last resort. I myself don't feel at all uncomfortable with the idea of ministers being faced with having to make this choice perhaps a little bit earlier and then facing up to the consequence. So to that extent, I think the Information Commission has got a point. If ministers think the issue really is of fundamental importance, then making the decision earlier and then being subject to judicial review if people don't like what we've done strikes me as being a perfectly sensible way forward. Of course, it is true to say that if you do that, then the ministers are deprived of the advantage of hearing the reasoning of the tribunal, which of course might have some bearing on their eventual decision. As I say, as it happens in the case of the Prince of Wales's correspondence, I read very carefully the extremely closely reasoned conclusions of the upper tier tribunal, but I must say that when I'd done so, I found myself in actually fairly fundamental disagreement with the way they'd approached this matter.
Given that you've been kind enough to turn up and give evidence to us, and you served for over 4 years as Attorney General, can I ask you about the protection for law officers' advice? There is currently an exemption for the provision of advice by any of the law officers or any request for the provision of such advice. Is that an exemption that should and can be maintained given the intense pressure there has been for the release of law officers' advice and instructions?
I've always been of the view that if the law officers are to provide full and frank advice to government, then it is necessary that unless the government, as the client, wishes to waive their privilege, in a sense their legal professional privilege, it's desirable that that advice should be provided privately. There are obvious reasons for this. I realise that the fear is that somehow thereafter, when the government presents its public case, it will massage the attorney's advice to present it in some more nuanced or perhaps less nuanced, more clear-cut way than the nuance which the attorney may have provided.
The Iraq example.
Iraq is the example.
Yes.
We still wait for the Chalkett inquiry to shed light on it, so I've always been a bit hesitant about pronouncing on this particular issue. I mean, clearly the attorney is both a politician and a lawyer. It's rather customary nowadays that the Prime Minister, when he's about to make a serious announcement at which he's at least going to accept that he's taken the attorney's advice, usually requires the attorney to sit rather close to him on the green benches, the Treasury benches in the House of Commons. I mean, the bottom line is if the attorney feels really uncomfortable about this because the Prime Minister is about to say something which is rather at variance with what he's advised, he shouldn't be there or he should resign. As long as he's satisfied that the government is operating in a way that is compatible with his advice, then he will go and sit and look cheerful, or as cheerful as possible, sitting next to the Prime Minister. But I do think that the danger that we're going to run is that if it were to become routine for the attorney's advice to be published, then inevitably the attorney's advice would start to be tailored for public consumption, whereas it's really important that the attorney's advice should not be tailored for public consumption, but should set out both the pros and cons of a policy. And one of the points I keep on making to people is that lots of areas where the attorney has to advise, it is possible for reasonable people to disagree in how the law should be interpreted, particularly when you're dealing with matters of international law, where ultimately there's very frequently no tribunal that can adjudicate upon it. It's a difficult area.
Following your helpful tip to the media to look carefully at where the Attorney General or the Solicitor General are sitting at any given time, can we turn briefly to the public interest test? Would you be in favour of an attempt being made to define more closely what the public interest is, or do you prefer something more akin to a common law approach, perhaps, of leaving the public interest as a more elastic matter and one which is contextually driven?
Discuss. It's a very difficult question to answer. Perhaps I can just say this. I didn't find the public interest test as set out in the Freedom of Information Act particularly wanting. I didn't find it difficult to deal with myself, or I think on the occasions when I was considering it. Of course, you could draw it more tightly if you wanted to. Of course, I mean, there are two ways in which this can be approached. One is you could provide for more absolute exemptions and then tighten up the test otherwise. That's one way of approaching it. Or you leave the broad measure of the qualified exemptions as they are and the test as it is. I don't really, the risk of being unhelpful to the committee, I don't find that an easy question to answer. And the danger is that if just talking off the top of my head, I'll come up with an answer I might regret afterwards. It's not unworkable. I mean, before one starts to slate the Freedom of Information Act too much, some people say it's cost too much money to run, but it's had, when you look at the problems associated with it, it's had some very good positives to it as well. I know that Tony Blair said he regretted very much having done it, but I don't think that I personally, as a politician, looking back on it 15 years later, think it was the wrong direction of travel at all.
Thank you. Mr. Straw will be pleased to hear that opinion. Thank you, Chairman.
Thank you very much. Well, sorry, one further question. We've had quite a lot of comment that the appeals process is lengthy, and the question of whether or not it should be streamlined has come up several times, is whether or not one or more layers of this process should be removed. Do you have a view about that? I mean, if not, I mean, don't worry.
It is lengthy, and it would be, if it could be streamlined, that would be absolutely marvellous. I mean, I think, on the whole, as a lawyer, despite the fact lawyers are supposed to earn money from lengthy legal processes, streamlining them is very desirable. The more interesting question is what you can do to achieve that. In many cases, it's a matter of timing, it seems to me, and fitting it, and just the volume which tribunals or commissioners have to deal with. You will be better placed than I will in taking your evidence, but clear as to what the best course of action would be. But I mean, clearly, I mean, taking the Evans and the Attorney General as an example, admittedly going all the way to the Supreme Court, this was a long drawn-out process, and of course that's not desirable. Anything that can be done to try to shorten that would have been very good.
I think, if I correctly understood your evidence, Mr. Grieve, you did suggest earlier on a possible streamlining in relation to the ministerial veto if you excluded the first-tier tribunal and allowed a point of law appeal to the upper tribunal or to the High Court on judicial review, which comes to much the same sort of thing. Yeah. That was what you had in mind.
Yes, I mean, I think what I had in mind was that the system provides for two parallel tracks. One is a system which goes up to the upper tier tribunal and then eventually potentially to the Court of Appeal on a point of law, which is a legal route. The second one is a route where the government takes a view at an earlier stage that in fact this really is ministerial veto territory, therefore grasps that particular nettle, exercises the veto before the tribunal stage is engaged, and then accepts that there will be judicial review thereafter. Now, of course, judicial review can take some time, But it would avoid where we ended up, which is, as I say, this, I think, rather unfortunate situation, where firstly ministers were seen as overriding a decision of a superior court of record, which is not going to make the judiciary very comfortable for understandable reasons of the separation of powers. And secondly, of course, pulls it out in an even longer period. So it would have the merit of shortening the system, but it would mean that ministers were deprived of the advantage of seeing the upper tribunal's reasoning before deciding on the veto. That would be a loss. There's no doubt about it. It's useful to have that information. And secondly, they would be deprived of that, and they would also have to come to a decision faster, which ministers are often rather reluctant to do. If they can put it off a little bit, sometimes that suits them rather well.
Mr. Grieve, could I just ask you this? Lord Newberger, in his lead judgment, recited the fact that Dinah Rose, who was counsel for Mr. Evans and the Guardian, had, as it were, conceded that if the veto had been exercised at the point of the Information Commissioner's decision, then none of the major constitutional, I paraphrase, none of the major constitutional issues which were raised later would have arisen. But he then, Lord Newberger, having said that, then went on to say that, this is paragraph 80, quotes, "There must, however, be a powerful case for saying that it would at least often be a misuse of the Section 53 power, the veto power, to issue a certificate on certain grounds when it would be possible to appeal to the tribunal under Section 57 on the same grounds." In other words, a test of reasonableness, not whether you had reasonable arguments, but whether, as it were, it was reasonable to exercise the veto, would be whether an appeal would lie. Do you think it's possible to deal with that issue by careful drafting?
Well, I would hope it was, but it does mean, those effective words, and obviously I've read the judgment, is that Section 53 is dead. I mean, the clear implication of that was that even if you wanted to use Section 53 at the moment to exercise the veto at an earlier stage, you might well fall foul of the Supreme Court at the end of the day on reasonableness of the route you've taken. But I think it is open to Parliament, if it is clear, to deal with that. And I'd be interested to know what you might obviously want to hear from some jurists or other lawyers about this, as to whether this is such an unusual route. But I don't find myself seeing that there's a constitutional horror in, at an early stage, the government deciding whether this is an issue which is so important that the minister should make the decision and then take the consequences, or say that essentially the minister says that although they may be arguing against it, they're quite prepared to see it go through a judicial process of review to determine whether it should be put in the public domain or not. I don't see that as being in some way conceptually wrong, but somebody may persuade you or me that I'm wrong about that. But I find it difficult to see why that concept should be wrong.
It's been very helpful, and we've overrun a few minutes, but it was very interesting material.
Thank you.
Lord Beith, good afternoon.
Good afternoon.
Very nice to see you. Do you have anything by way of opening remarks to make?
If I may, just partly to make clear that obviously I can't speak on behalf of the Justice Committee, which is a new form in a new Parliament, but I stand by the conclusions in its 2012 report, which had all party support. Indeed, 3 of its then members are now ministers and 1 is the leader of the opposition. Freedom of information is, we thought, a significant enhancement of our democracy, and its benefits outweighed its problems and disadvantages. The committee did not find, and nor did the Constitution Unit, on whose research we relied to some extent, that there was much reliable evidence of the inhibiting of policy discussions at senior level, but we acknowledged that there might be a perception that there was no longer a sufficiently safe space. We recognised that there would be occasions when it would be right for the ministerial veto to be used to protect that space. But the key point I want to make to you this afternoon, apart from one other different point, is that freedom of information is only one of several ways in which the safe space is threatened. Leaks, disclosures to court, public inquiries, publication under the 30-year rule, memoirs now published frequently after people have barely left office and must have been writing extensively while they were in office. All these are routes to information emerging from that supposedly safe space. And even if the Freedom of Information Act were to be altered, you could not say, as a permanent secretary in a department, to somebody, oh, don't worry, you can put what you like in that document, it will never be seen because we've modified the Freedom of Information Act. Because in the process of doing that, I think you would have done great harm to something which is of real public benefit. And it's better to have a general right than merely a selective opportunity to disclose only one part of the story. FOI means that the citizen, organisations and the media can get access to the whole story, not just the information selected by individual ministers, squabbling special advisors, people with a grudge, or the number 10 press office. The one other point I'd make would be about privatisation and outsourcing, simply to underline that we observed in our report that where public functions were outsourced, particularly in local government, there were already arrangements in hand in many instances for the necessary information for FOI to be available to the authority, which was then held responsible for producing it. That is, in our view, was the right way to go about it. And if there's any question about it not being done by some bodies outsourcing functions, then that should be attended to.
Thank you very much. Patricia.
You spoke of the balance of public interest in safe space and the public interest in revealing government deliberations. And your report concluded that the existing protections properly used were sufficient to protect the safe space, which I think you have just repeated to us. If so, why does the Act continue to cause so much anxiety to officials and governments?
What I did not seek to imply is that there have been no argument and no questions about the safe space. Indeed, quite a lot has happened since the committee produced its report. But the question you've actually asked me is, why is it still discussed? Well, it is inconvenient to ministers and to officials. And some of the particular instances when information is refused, the various powers are exercised, clearly give rise to argument and discussion in itself. And the organisations which are seeking the information then make waves about it. This is an area about which governments and ministers and some civil servants are very sensitive. And there will be argument, but that argument is a sign of the value of information disclosed. And most of us, particularly even in Parliament, have experience of the inconvenience of disclosure. I put it no more strongly than that, because you then have to mount an explanation for things which on the face of it are criticised. But that's accountability.
But you prefaced that remark by saying there were proper questions about its operation. How would you characterise those?
What I was describing rather loosely was what you've just been discussing with the former Attorney General, which is the precise definition and reliability of the safe space protection provided by the veto is not entirely clear. Now, I want to preface anything further I say by pointing out that the disclosures that have taken place have not brought the sky in. The sun has not ceased to shine. Public administration has not collapsed. And therefore, although there are some interesting legal arguments around this, and you expose them very effectively in the exchanges which have just taken place, to respond to those difficulties by in any way diminishing the ability of citizens and organisations and the media to achieve greater accountability would be a great mistake.
But you would agree that the Supreme Court decision has created additional uncertainty over the use of the veto?
It has probably increased the uncertainty to which the committee referred when it felt that quite a lot of uncertainty could be removed if people in public office were reminded of what the existing rules were. Clearly, the existing rules are less clear than they appeared to be before the Supreme Court ruling. But I'm cautioning that this interesting, fascinating argument has to be set against both the huge benefits of freedom of information and the experience of the very disclosures which have occasioned these legal arguments, which have now taken place without appalling consequences.
Of course, we are in new territory following the Supreme Court decision, and I wonder if you have any thoughts about whether there might be positive ways of retaining all the benefits you describe while reducing the additional level of uncertainty that's been imported as a result of that decision.
I think there's a discussion to be had about the structure of the appeals system and the various levels that it has, and you engage with Dominic Grieve on some of that, and my colleague Lord Marks has put forward some proposals on that, and I think that could be helpful from various points of view. But I return constantly to the point that even if you had restored some of the safety which we perhaps thought originally could exist in terms of advising people that FOI would not be attracted by that particular discussion or document, those same discussions and documents are exposed to so many other risks of disclosure that you would be misleading public servants if you said, don't worry about the possibility that somebody may one day see what you have written. It's not very good advice to be giving them anyway. Indeed, in many cases, I think civil servants have an interest in the documents showing that they pointed out some of the problems which might arise, rather than remaining silent. And if you want to take one of the most dramatic recent examples, Oliver Letwin may feel that his views have changed very substantially since he wrote a paper so many years ago, which caused him such distress at New Year. But that emerged not from the essence of FOI, but from the 30-year rule, which I'm sure we would have even if we adopted the legislation.
We heard last week from Lord O'Donnell of his particular concerns about the public interest test, and that was explored a little bit in the last session, which I think you were present for. Lord O'Donnell issued a plea for greater clarity, more certainty. Do you think there is anything in this? I mean, how could one clarify it, or is the public interest something that evolves over time, as in fact we heard from other people giving evidence last week?
Well, that was as far as we felt able to go in accommodating Lord O'Donnell's points to us, that the greater clarity was desirable. But of course, the public interest test can't be used against every disclosure the government doesn't like on the grounds that repeated disclosures will lead to people believing there is no safe space, even though in each of the given cases, the relevant bodies ruled that there was a real public interest in the information becoming known. But it's become quite a difficult area, as your earlier discussion showed.
Could I just ask you to say a little bit more about the appeal structure and the point at which any necessary ministerial veto, which I think your committee accepted a necessary backstop, point at which it should be exercised, and whether government should legislate to clarify?
Well, I was very interested in what Dominic Grieve said about that, about the advantages in the government having to consider the reasoning of the upper tribunal before deciding whether to exercise its veto. And I can see, in principle, at least, merit in that. So I don't have a firm view about it, other than that the existing system is multi-layered and complicated and takes a long time to achieve objectives which all parties would want to get achieved more quickly. It's an area worth discussion, but I suppose I have an underlying reluctance to see new legislation in an area where we've legislated to such beneficial effect, and we could easily get it wrong again. If, insofar as there's a technical defect in that area, which the Supreme Court found in the idea of a minister overruling a court of record, that arose, that particular bit of the legislation arose in the detailed discussions which took place as Parliament sought to get it right. But it's very difficult to find a perfect answer, and the risk, I wouldn't want us to do so at the risk of damaging the fundamental principles.
We seem to have got into a slightly strange space, it seems to me, where the campaign for freedom of information has pointed out that over the last 5 years, in the bulk of the cases that have gone to the Information Commissioner, he has upheld the public authorities' view in terms of Section 35. There have then also been quite a lot of cases where the first-tier tribunal has overturned the Information Commissioner on this, which suggests to me that, well, it demonstrates to me the extent to which this issue of balancing the public interest test, is a fine art rather than something that is automatic. So the outcome has not been particularly harmful in relation to information that has been released, and yet, as Lord O'Donnell said, people still feel in a state of great uncertainty, as if they feel that they're playing the lottery each time that they find themselves in this position, because the outcome is uncertain. And what we have been trying to probe is to what extent it might be possible to clarify some of this, so that not that the outcome was different in terms of the information that is released, but so that, in a sense, both parties, to both the requesters and the public authority, could have a greater degree of certainty of how this is going to turn out. But maybe it's inherent in public interest tests that there will always be a substantial uncertainty.
The outcome of art can never be certain. The answer is in your own question. And the more I've looked at it, the more I've questioned how much certainty you can really offer. Or what you are saying in the process operates as it was intended to do, is that that information will be disclosed unless to do so would impinge on the necessity for collective cabinet responsibility and high-level policy discussion at which risks are fully and frankly examined. There may be circumstances in which even that information will be disclosed because there's an overriding public interest in doing so, yes. But there's a general recognition that we should, so far as possible, try to preserve that space. You can't make it more certain than that. And if you did, you'd be saying, at least in some cases, that some matters where we really should have known what happened in that discussion will not be known, or at least not until the 30-year rule allows
or 20 years.
No, 20-year rule.
You make some extremely valid points about the difficulty of achieving certainty, but perhaps it's possible to achieve greater clarity.
Yes, I think it's reasonable to try to do so, but my suspicion is that if, with the finest minds we can assemble, we put together some legislative change sought to do that, either it wouldn't work or it would have the unintended effect of inhibiting the general right. And why? In order to stop one route to disclosure when there are so many others which are more selective in character. So I'm really urging extreme caution in an area where we have, as we have demonstrated today, been unable to predict with certainty what the outcome of words in legislation would be. At the moment, we have a reasonably happy outcome, except for those governments that are embarrassed by the things that are disclosed.
The Administrative Court now produces a digest of decisions which provide guidance to judges who may encounter similar issues from time to time. And for those who sit as judges in the Admin Court, it's very useful. Would you favour the production of practical guidance and a digest of decisions to the same end in this difficult area?
Yes, I would. I think as a general practice in law and tribunals should know how previous cases have been decided.
Thank you very much.
Thank you.
Patricia, you have another one?
Yes, just a couple more I'd like.
Oh, Carl, I'm sorry.
And it was shifting subject. We're also focused on the safe space of veto and clarity, of course. This is reverting to the cost of process.
To the
cost of the process of FOI requests to authorities and to meeting them. And we have received evidence about the cost of activities over which the public authorities have no choice or control, like necessary redactions to protect personal information and so on, and the fact that these cannot be counted within the cost of the process at present. Your report in 2012 concluded it wasn't appropriate for activities like redaction to be included in assessing whether or not a request exceeded the cost limit. I wonder whether you might not reflect on the basis of what we've heard, that there are particular cases where the public authority has no choice and which are additional to the normal costs of meeting the request.
Well, we received evidence in both directions, as I recall, on that argument, and we reached the conclusion that it was neither necessary nor desirable to complicate the system by introducing a charge caused by redaction or altering the limit to take account of redaction. And a number of the public authorities that spoke to us did not seem actively to seek that particular outcome. It looked to us that it would both be complicated and could, of course, bring into a charging regime requests which otherwise wouldn't be so treated.
Thank you. The Information Commissioner referred us to a number of the recommendations made by your committee that haven't been implemented. Are there any that you would particularly wish to draw to our attention?
Well, actually, I would like to have a clearer picture of how much progress there's been on the outsourcing privatisation issue that I mentioned earlier. And because the information we had is probably becoming out of date now, as many more functions have taken that route. Some of our proposals relating to university research were implemented. But as with many committee reports, if I went through, I could probably pick up some others that I think the government ought to get on with. But this was not one of those reports which is urging the government into legislation generally, rather the contrary.
No, you've made that clear. Thank you very much.
Thank you.
Thank you very much, Lord Beith. Good afternoon, and thank you so much for coming. We've all had a copy of your report, and there's been a good deal of interest in it. And as you will have heard this afternoon, we have the subject has come up a number of times. And we're very grateful that you are willing to come here to talk to us about it. Do you want to make any opening remarks?
Yes, I would make a few words. Thank you. Thank you, obviously, for having us here to speak to you. We would make a few remarks just amplifying part of the argument of the paper. We take a view, as you see in the report, that the action you see in Evans is problematic in rule of law terms, but of course, as you've seen this afternoon and elsewhere, there's an argument that the ministerial veto is itself problematic in rule of law terms. And that seems to be a shared premise in the Evans judgment of the Supreme Court. But it seems to us a misconceived line of argument. The question that, the relevant question at least for decision by departments, the Information Commissioner, the Upper Tribunal and the Attorney General was the same question about the balance of public interests. And that's not a question especially suited, it seems to us, for judicial determination. On the contrary, it's a classic question for the executive. So one might argue that it's constitutionally problematic for Parliament to authorise on a judicial body to determine that question. It's arguable, but it seems to us that it's not problematic to reserve to ministers the final decision about where the balance of public interest lies. Of course, one might choose or not choose to have an executive override, but that choice doesn't seem to us to be unconstitutional.
And I thank the Commission also for inviting us today before I begin my introductory remarks. Our concern is primarily constitutional. We consider that the Supreme Court in Evans misinterpreted Section 53 to give it a meaning that Parliament clearly did not intend. It seems to us almost undeniable that the ministerial veto was clearly intended to be a central feature of the Act, to use the words that Lord Wilson did in his dissent. But the majority judgments in Evans, particularly those that of Lord Neuberger, adopt a meaning of Section 53 that denudes the section of significant effect. This is contrary to the scheme of the 2000 Act, in which Parliament chose that where the information involved was subject to qualified exemption, there should be an executive veto, with the appropriate minister having the final word on where the balance of public interest lay. The effect of Evans is to change that whole scheme of the Act without any parliamentary warrant, therefore, and we think that that is constitutionally improper. It must be accepted by all who administer the law, including the Supreme Court, that the laws laid down by Parliament should be applied. The heart of the Supreme Court's justification for its decision lies in the fact if the veto operated as Parliament had intended, the executive would be overruling a judicial decision, contrary, said Lord Neuberger, to constitutional principle. While such a situation is unusual, it is not unprecedented, and if what Parliament enacted was such a veto, the Supreme Court and everyone else for that matter must accept that. It may be that one thinks that the executive override is unnecessary or redundant, that there could be better ways of doing that, but while Parliament has so enacted the 2000 Act, we have to accept that. And I think that's our prime constitutional starting point. I think we are going to want to say something else about alternatives to a direct direct legislative overruling of the Evans case. Some of the discussion in earlier sessions covered that, and we'll probably have an opportunity to talk about that.
Just going straight to that, you said, Professor Forsyth, just a moment ago, that there could be better ways of doing it, and said that you thought there might be alternatives.
Yeah.
Would you like to expand on that, please?
Well, I've listened very intently and with great interest to the suggestion of the Information Commissioner that the ministerial veto should only affect decisions of the Information Commissioner. That doesn't seem to me to be a satisfactory alternative. And the reason why that is so is in part what you do when the Information Commissioner upholds the public authority. There's no veto to be exercised then, and it may only become clear that a veto is needed when the upper tribunal takes a different view of where the public interest lies. So that strikes me as a practical difficulty with that particular solution. And you have, of course, the problem, which I think the chairman adverted to, that Lord Neuberger in his judgment specifically says that if you were to exercise the veto while there was still a live appeal outstanding, that would be a misuse of power.
Well, I think Lord Neuberger said if an appeal was, if it were possible to appeal, not an appeal outstanding.
Yes, if it were possible.
So you have to exercise your right of appeal rather than veto.
Yeah, and that would go to the issue of reasonableness.
Yes.
But so, accepting this conundrum, what is your solution to this?
Well, our prime solution that our paper argues for is, of course, that remedial legislation should be passed that reinstates the veto in the terms that Parliament actually intended. But if the Commission is looking for another way out, what occurs to us, I think Richard agrees with me on this, what occurs to us is that one should make a slight amendment to, I think it will be Section 58 of the Act, dealing with on what grounds you can appeal. and to remove the provision that allows an appeal to lie to the upper tribunal or beyond the Commissioner on the grounds of taking a different view of the balance of interest. Because crucially, this is about where the balance of public interest lies. And that is, in our view, essentially an executive function, not a judicial function. And why we're in this difficulty is because we've allowed the judges, whether in the upper tribunal or beyond that, to take a view on where the balance of public interest lies. That's an executive function, and it should be exercised by the executive. So if you were to exclude the possibility of appealing on the grounds that the balance of public interest had been got wrong by the Information Commissioner, then there could be appeals beyond the upper tribunal, the Supreme Court or wherever, on grounds other than that, but the public interest would be protected from a judicial override, so to speak. It would, of course, be possible always to judicially review the Information Commissioner and so forth, but that strikes me as a better solution than simply restricting.
So as it were, Section 58(1) has two limbs.
Yes.
That the first is an appeal against that the notice against which the appeal is brought is not in accordance with the law, or to the extent that the notice involves an exercise of discretion by the Commissioner, that he ought to have exercised his discretion differently. So, Professor Forsyth, you're saying that, as it were, the second limb should be deleted.
Should be deleted or appropriately amended.
And then, you then have, would you have, well, let me ask you this question, would the appeal to the tribunal on a point of law then be wider or the same as if there were a challenge to an Information Commissioner or ministerial decision by way of judicial review? Would they amount to the same thing or would they be different?
I think they'd be, in principle, they'd be much the same thing, in the sense that whether on the appeal or whether on the judicial review, it should be recognised that the question of a balance of public interest is something that lies within the ambit of the executive, not within the ambit of the judiciary. So it wouldn't be a ground of judicial review to say you got the balance of public interest wrong. I mean, you could still challenge it, of course, if there was something outrageous in the finding of the balance of public interest. But in the normal run of events where it could go one way, it could go the other way, you wouldn't be able to get judicial review on the basis that the balance of public interest had been got wrong. Similarly, with the amendment to Section 58, as we've discussed, you wouldn't be able to go to the upper tribunal on a balance of public interest point either. This doesn't mean to say that nobody cares about the balance of public interest, of course, because the Minister who exercises the veto would be accountable to Parliament in the ways that we've described in our paper, which I'm sure are familiar to the Commission, for the proper exercise of their...
Yeah. Can I just say, I don't have, I think this is a perfectly reasonable alternative, but I don't have a view on the merits of these alternatives as sort of ideal freedom of information legislation. I think either alternative is constitutionally proper and for Parliament to choose. And the question partly is how much value is there in the upper tribunal reconsidering questions of the balance of public interest. But if they are going to do that, then I think it makes some sense, or at least it shouldn't be ruled off the table for there to be a reservation of that question to ministers, the public interest question, in which case one would want to reinstate, to restore the veto rather than letting it be defunct.
And dealing with an earlier point you raised, Professor Forsyth, which arose in the Evans case, where in the Evans case the Information Commissioner confirmed the decision of the public authority to withhold disclosure, and there was therefore
nothing to veto.
Notice which could be vetoed. Would one way of dealing with that issue be to have, and this has been suggested to us, that there would be a power to the relevant minister to exercise an override, either to override the Commissioner's decision where he was requiring disclosure or to confirm it where, as in Evans, he was coming to the same view as the public authority.
So the suggestion is that the Minister, before there's ever been an appeal against a decision upholding the public authority, would confirm it.
Yes. So it would have the same. Which, you know, as we know, in the case of Evans, unlike all the other veto cases of which I'm aware, the Commissioner came to the same view as the public authority, so there was nothing within the current terms of Section 53 for the relevant Minister to override by way of a Section 53 veto. So that's why.
Can I say this? I mean, so it's a veto or a confirmation in a way.
Yeah, that's right.
These cases take a long time, as we know, they can do. And the judgment of the public interest, the balance of public interest, should be made at the time of disclosure, I think. So there is a bit of a risk, I think, in requiring there to be a veto or confirmation at the Information Commissioner point. Namely, it might not look as though at this point in time that it would be damaging the public interest for there to be disclosure, and so one doesn't exercise the confirmation power. And yet 2 years later, well, one takes a different view, or one might want to take a different view and be entitled to, or should be entitled to, and yet have that option having been ruled out.
But could I just put this point? If one, you've read the Evans judgments carefully, so have all members of the Commission, including me. One thing that comes through very clearly in these is a sort of sense by the judges who consider the matter at the Court of Appeal and the majority in the Supreme Court of really sort of irritation that a huge amount of time had been spent, particularly in the upper tribunal, considering the evidence and hearing expert witnesses and so on. And yet all that was then rendered nugatory by the stroke of the Attorney General's pen. And the implication from that, and indeed from Lord Neuberger quoting Diana Rose, counsel for Evans, is that some of this irritation would have been avoided and a sort of challenge to the supremacy of the courts if the veto decision had been exercisable at an earlier stage. Do you think there's something in that?
I'm sure the court was irritated. And it might be right that it would save considerable time and expense, at least in some cases, for this all to be brought forward. But there is a cost to so doing. Now, one can deal with that problem, I think, by, as Professor Forsyth suggested, cutting off the right of appeal on the grounds of public interest. But it has a cost as well. So I think the court is viewing this, the Supreme Court and the Court of Appeal for that matter, viewing it just too crudely, really. Seeing judicial body decision, ministerial override, isn't this flouting the rule of law? And when you look at the particular question that's being decided, the origin of the scheme, in fact, the way this comes before a superior judicial body at all, because the initial tribunal in which this is first conferred is not a court of record. It's almost accidental that it comes before court of record by way of the restructuring of the tribunals. So I think that they're looking at it, and they're looking at it too crudely, and if one looks at it in a slightly more fine-grained way, the constitutional problem just dissolves, really.
How does it dissolve?
Well, it dissolves because this isn't like the High Court issuing a writ of habeas corpus and a minister cancelling it. This is the question about the balance of public interests that's been conferred with the same question that each of these bodies has to answer: Department, Information Commissioner, and so forth. And it's, I think, perfectly reasonable, I'm not saying whether it's a good idea or not, to confer a scheme that requires each of these different bodies to make the same decision, and yet leave there to be a final catch-all on the part of ministers to make the same judgment again, which is not a classically judicial judgment to be making at all. And you can give it to a court, of course you can, or you can give it to a tribunal and deem the tribunal a court, but it doesn't change the nature of the question.
Okay. And last question from me. I think you've already indicated the answer, but as you will have heard, we've had some evidence that there should be a streamlining of the appeal process. If Professor Forsyth's proposal to remove the second limb of 58(1) was adopted, that in any event would obviously reduce the grounds for appeal. But do you have any general views about streamlining the appeal process? Let us say that 58 stayed as it was. Is there scope for reducing the grounds of appeal?
think this is a general issue.
It is a general issue.
I mean,
but if you haven't...
the law's delays are well known to all of us and how we can avoid them in this situation. I'm not sure I've got anything unique to say on
But you might have something well informed. Whether it's unique or not is another matter.
This isn't an answer to your question, I'm afraid, so I'm not going to help you streamline it. But there might be need to be quite careful in reframing Section 58 if one were to go down that route, because what does count as the ground of appeal? If that's unclear, then the same question will arise again in a court. I mean, you quoted the remarks from Lord Neuberger before. If it looks as though there's an executive action that's cutting off what would otherwise be a sort of robust right of appeal, that executive action and the legislative conferral of it will be viewed, interpreted perhaps in surprising ways. So I think one needs to be very, very careful how one frames that.
Yeah, well, I see this ambiguity because there was one case I was looking at where the upper tribunal was questioning the interpretation, I think it was, of the first tribunal in relation to some of the evidence that it used in the public interest test, which it classified as overruling it on a point of law, rather than overruling it on a point of, of a different view about the public interest. And I'm not quite sure, that there is a very clear demarcation between the two things.
I think it might well be that the question of law in Section 58 might well be taken to go to the question of the balance of public interests in Section 1 and so forth. So removing the second, removing the question of discretion might not answer the point. Might go rather to the discretion as to the particular remedial orders and so forth.
Thank you very much, and thanks for your time, and thanks for your paper, which are a very interesting contribution to this debate.
Thank you very much.
Frankel, thank you so much for coming, and you have been extraordinarily patient sitting through the two sessions that we have had. At times I've tried to interpret your expression as the days have gone on, but I think it would be better that we should actually hear from you in person. And we've allocated a reasonable amount of time where I hope we can deal with the issues that we have. And particularly thank you for your evidence, which is very helpful, and you go into a great deal of detail in terms of analysing how the particular issues that we have been asked to look at have developed over time. Do you want to say anything by way of introductory remarks?
There are a number of issues from the previous evidence sessions today and previous that I would like to respond to, but I'd be very happy to try and bring them in response to your questions rather than take up another slot just speaking before you put the issues you want to hear from me to me.
May I echo the thanks of the Chairman, Mr. Frankel, for all the evidence you and your colleagues have put forward, and sort of the huge assiduity you've put into this issue, not only for these proceedings, but over many years. Just picking up your first point, I wondered if you were here, as you have been for all the oral evidence, for the evidence from Councillor David Simmonds, representing the Local Government Association. And here I paraphrase, but said words to the effect that if he were asked, or local authorities were asked for information, then they could either give it straight away, or they'd have to say, this is an FOI request. If you want to make an FOI request, you've got to go into a sort of bureaucratic machine. I was surprised about this, but do you think that the Freedom of Information Act either was intended or does operate in this way? Surely if someone is given the information, then they're given the information.
I was very surprised by what Mr. Simmonds said. Section 11 allows the response to be made by, in accordance with the requester's preference, so long as it's reasonably practicable. You obviously picked up the reasonably, which he said was not there. There's a second thing that he... So in other words, no requester can ask the authority to do something very burdensome if there's a simpler way of doing it. There's a second thing which Section 11 at the end does, which says that it sets out now four ways of responding to the request, which involve providing the information in a permanent form or in other form acceptable to the applicant. That means a non-permanent form. The most common non-permanent form is to tell the person. That's what that must mean. Now, so when he said you can't give the answer by telling the person, that's wrong as a matter of the Act. It's worse than that, because if you look at the LGA's evidence, they're calling for that phrase to be deleted from Section 11. They're actually calling for the phrase that allows them to answer simply to be deleted on the grounds that gives the, on the mistaken grounds, that it gives the requester the power to force disclosure in a form the requester chooses, to which they have no grounds to object on practicality and cost. So I thought that was completely off target.
And, sorry, Michael.
I want to make sure I understand this,
Yeah.
and I'm not sure I do.
Yeah.
Because if the Act says the information has got to be provided in accordance with the preference of the requester, as long as it's, unless it's not reasonably practicable to do so. Well, even though the information may more readily be available in a different form, even though it may be available, even though it may have been given, the requester could still argue that it's reasonably practicable to give it in a form which he wants.
Well, there's two separate questions tied up here. If the information is already publicly available, then there's an exemption. That's Section 21, or Section 22. It's already available, and Section 11 doesn't come into it. You can't force the authority to rewrite the information in tabulate it differently because you prefer it. If it's already publicly available, you just cite the exemption.
But if it's an FOI request?
Sorry?
But if it's an FOI request?
If it's an FOI request, the authority can, as long as all the requested information is publicly accessible already, the authority can cite the exemption and is not required to put it in to retabulate it.
Yes, but if the exemption doesn't apply, so it's not publicly available, but the situation that Councillor Simmonds identified, where he says to the requester, look, I can give you this information, I can write you a letter, it'll take much longer if you go through the FOI route, but the requester says, no, I want to go through the FOI route, and the authority can't argue that it's not reasonably practicable to give the information in that way, he's got to do it.
Yes, I mean, yes, but that doesn't rule out giving the... I mean, the authority cannot insist on giving it to you verbally if you, the requester, want it in
verbally,
writing.
in a letter.
Yes.
Sorry?
Not, I mean...
Well, in a letter is a perfectly conventional way of responding to an FOI request.
Confusing two issues here. The Local Government Association said you can't give it orally. You are pointing out, probably rightly, that you can give it orally. But if the person isn't prepared to accept it orally, then you go into Section 21.
Oh, then you go into Section 21 if it's already available. But if it's not available, then you have to provide it in writing.
But if you've already written a letter, given the information, even if it hasn't got FOI request reply stamped on it, that's already been given, and that's the end of it.
Yes, you provided the information.
Yeah, sure. Okay.
There's recent decision from the Court of Appeal, from the Upper Tribunal Court of Appeal, saying you can say if it's in a PDF and you want it in an Excel format, and that is reasonably practicable, you can require it in that format.
Yeah.
But that's it.
Well, no, we're familiar with that.
Yeah.
But can I just pick up another point that was raised during the course of the evidence session this afternoon, and that was from Mr. Clifton of the Press Association, Mr. Satchwell of the Society of Editors. Mr. Satchwell said that cooperation between, as it were, the two sides had been and understanding greatly helped when there was a users group.
Yeah.
And he thought that would be very helpful for the future.
Yeah.
What's your view about this?
I completely agree with that. I was a member of that same user group. A minister sat at it, the commissioner sat at it, local government association, NHS, some independent people and 2 press organisations, and it was a very useful forum at which problems that the other side hadn't seen were brought by one party or another. And I think it was helpful in improving people's understanding of what was working and not working.
And would it also, if we were to recommend this, would it not be a good idea, looking forward, for there to be someone there from the Office of National Statistics as well? Because quite a lot of it seems to me, we've not taken evidence on this, but that some of the really important information that people are having to request through FOI applications could better be made available in data series that are published routinely by people subject to the ONS.
Whether that's for the ONS or whether that's something to be done through the open data movement is a separate question, but I agree with the thruster of what you're saying, that one should look at whether it can be done by publishing data sets, so that the information is available routinely.
The area with which I'm very familiar is criminal justice, and the more you can provide reliable data through the official statistics, the less people have to get frustrated about the fact that particular information is not available. Could I, Mr. Frankel, move on now to deal with this issue of sort of relationship between Section 35 and 36, safe space and chilling effect. And particularly this argument, which is at the heart of much of the evidence we've received, which is either concern or support, put according to your point of view, for the notion that safe space basically, in principle, ends when a decision is made, and then all that's left is chilling effect. I mean, do you think it's that mechanical? And do you accept that the issue of a safe space may well continue, given the reality of decision-making in government, which is on the same issue? You'll have a series of submissions coming forward.
I don't think it's a mechanical process. Apart from anything else, even if one accepts the safe space ends when the decision's taken, the test is not, is there a chilling effect? The test is disclosure in the public interest. Where's the balance?
Sure.
And it's commonly translated as chilling effect, but there may be other consequences. The second thing is the upper tribunal has recently ruled that, particularly with a bill going through Parliament, you can go in and out of safe space as an issue which appeared to be closed is reopened. But I think that the way in which safe space is used in the FY context means while you're taking the decision. And then you go on to some other concept once the decision has been taken. But the tribunal at a very early stage has said they don't believe in they reject the endless web, the endless seam of consideration, where government says, well, we're always considering all of our policies, and therefore there's never an end to the safe space because, 10 years after the legislation is passed, we've still got at the back of my mind.
That's not my point, by the way. But there's a parallel issue here, which is whether, as it were, the horizontal safeguarding that's provided both within Section 35 and 36 for ministers to other ministers, private offices and so on, is stronger than the vertical protection provided for ministers and their officials. Have you got a view about that?
I know I picked this up from your questioning the other day. I don't particularly feel that to be the case. I think there are two things to take into account. The first is that one of the exemptions refers explicitly to ministerial communications. So when the government is arguing the case for ministerial communications, that's how they're describing the argument. The exemption that applies to discussions between officials and ministers is policy formulation more generally. Now, again, it may very often reflect the way the argument is put by the government's lawyers, the extent to which they're talking about an effect on the ability of officials to express their views properly, or whether they're talking about a general effect on policy formulation. But certainly in the survey that we did, there are a series of cases where the decision against disclosure was clearly taken in order to protect the position of officials in discussing with each other, or discussing or providing advice to ministers. And the clearest of those is the example of the draft parliamentary questions, where officials were commenting on what they assumed the MP who was putting the question down, what their motive or interest was, and they didn't want to dissuade the official, make the official feel vulnerable about expressing a possibly indiscreet view if it was immediately going to be disclosed to the MP who was asking the question. Well, I don't think there is. I don't myself detect that difference, because I think you don't see it very often, but I'm sure that what the tribunal says, if ministers are just discussing a convenient day to make an announcement, they wouldn't give much weight to that either. It was a ministerial communication that doesn't touch what they're now calling as the underlying rationale. Yeah.
That, which is, I don't think, anyway, I'm not talking about that, but to go back to, sorry about my frog, to go back to a point that I was making, I think, to Mr. Satchwell and Mr. Clifton.
Yeah.
The preserving confidence and trust between officials and ministers seems to me to be absolutely fundamental to good governance, particularly in a context in which the one, as it were, doesn't choose the other. And that seems to be a really powerful reason for there to be safeguards against premature publication of advice, even after a decision has been taken.
I don't see it quite like that. I think confidence and trust are not to do with an FOI disclosure. Confidence and trust are to do with leaks. If an official leaks what the minister has said to the official, or what the discussion is, that goes to the heart of confidence and trust between the minister and his or her advisors. If it's disclosed under FOI, the official has no responsibility for the decision to disclose at all. And I know that's what I'm saying. That confidence and trust may not be the right way to describe what's at stake here.
Can I put it? Look, I readily accept that leaks are pernicious wherever they've come from, and they will certainly undermine confidence and trust. And if there is a suspicion, although I can't ever think of an occasion where I was subject to a leak, or maybe one. It's very rare for the official concerned to be causing the leak, extremely rare. That would make it worse. But I'm talking about, as it were, and this is a subtle, I'm not arguing for of course, that the material should never be disclosed. It's about the time at which it should be disclosed. But and it's very difficult to put your finger on this, but if officials who can be middle-ranking officials these days, quite young, are having to tell senior ministers some truths which the senior ministers may not be terribly keen on hearing, it will just make their life more difficult if there is a possibility that what they're saying to these senior people, which could be embarrassing if it comes out, is going to be disclosed. And is that something you accept?
I do accept that.
Okay.
And I think that's a question of how sensitive the content of what the official has said is, and how long after it's been said the question of disclosure is raised. But I do accept that. If an official is telling the minister what you're doing is unworkable, minister, in my opinion, you have to look at the implications of disclosing that, certainly in the near future, certainly.
One last set of questions I wanted to raise, which is about the position of contractors, including charities. First, it's right, isn't it, that at the moment some contractors are covered by the Act, for example, under, I think, paragraph 43A of the Schedule 1, general practitioners are already covered, and these are entirely private. They're institutions. Do you have? I don't think we've had any evidence at all from general practitioners that this has been too great a burden on them. Are you aware of any evidence to that effect?
There have been cases where the vexatious test has come in at a much earlier stage in relation to general practitioners who are public authorities individually in their own right. And so in that way, they're not exposed to as much work. The Commissioner will not expose them to the same level of burden. But I don't think they're thought of as part of the National Health Service, although in law they may be contractors.
Well, I mean, but in reality they're contractors as well. I mean, but overall, your view is that although they are private contractors, which they are, I mean, as a matter of, I mean, they really are. They're very different from a hospital doctor. That them being subject to the free FOI has been relatively uncontroversial. Okay. So, and your view is that this provision, the same principle, should follow in respect of people, say, contracting with social service departments and other local authorities, and indeed more widely with the NHS. Would you have a de minimis level for very small?
We wouldn't bring all contractors under the Act as public authorities. What we would say is we'd bring the major contractors in as public authorities, the particularly very large players whose work is mainly with public. The other contractors...
Would that mean that all of their work, though, was then...
No, only their public authorities. Those who still had private sector work would not be affected in that respect of that. The general run of contractors would be covered by means of a request to the public authority. Now, they are already, but the difference is that the right of access is information held by the authority, and that includes information held by somebody else on behalf of the authority. So the question is, does the contractor hold the information on behalf of the authority? There's no dispute the contract is done on behalf of the authority, the function is on behalf of the authority, but peculiarly, the information relating to the performance of the function is not held on behalf of the authority unless the contract, either by a sufficiently wide general contractual clause or by specifically requiring the contractor to record that information and provide it if required, that is the test. And where the contract doesn't do that, then there's usually no right of access by means of a request to the contractor. So what we've proposed is you have simply an amendment to the FOI Act which says all information held by contractors or contractors providing public services relating to the performance of the contract is deemed to be held on behalf of the public authority. And that deals with that problem. It brings it immediately within the scope of the FOI Act. And in that case, I don't think it matters too much. I can still talk about it, whether the contractor is a very small charity or not, because all they have to do is explain to the authority what they've done that meets the terms of the request to the authority. They don't have to learn how the Act operates.
And would you accept...
Sorry. Can I just follow that up on the point, just to be clear, and I think you've made it clear. Are you saying there is no distinction in principle to be drawn between a contractor and a charity, provided the charity falls within the test that you've described of holding information on behalf of the public authority?
What I'm saying is that where the charity is a contractor, that where the charity is a contractor, there's absolutely no difference. I wouldn't distinguish in any way. They're all contractors.
Thank you.
Thank you.
It's clear.
Could I follow up with you the point I've raised with one or two of the witnesses in a way that what seems to me to be almost a standoff position that we've reached on some of the issues to do with 35 and 36, which is that when I go through the cases about which you recite in detail in your evidence, where the Commission has found against the public authority, by and large there isn't, there's very little material I can see in that has been damaging to government. We also have the case where a much higher proportion of FTT cases overturn the Information Commissioner on Section 35, 36 issues than for the bulk of their business, which suggests something to me about the uncertainty of it all. And I contrast that with the evidence that we had from Lord O'Donnell about the sort of deep uncertainty that is felt in Whitehall about how this is working. And the challenge that we have sort of been looking at is there any way in which you can reduce that degree of uncertainty whilst leaving, broadly speaking, unchanged the amount of information that would be released, as opposed to that which would not be released? Because there seems to be an unnecessary amount of tension, in a way, between the two sides of this debate.
Are you, Lord Beith, I noticed, obviously I picked up that question that you've put to other witnesses. When you say the tribunal overturns the commissioner, are you using the survey, the analysis that we provided, or are you using your own analysis or officials' advice?
I think we're using our own analysis
that
we have done, where we get numbers that are, and mind, the FTT overturns the Information Commissioner on 35, 36 issues in both directions.
Yeah.
I mean, it's not saying it's all in favour of the public authority. I mean, but it just strikes me as being a rather more uncertain territory, because the public interest test is probably more difficult in this area than the others.
I didn't find, based on the 3 years of FTT cases we looked at, we didn't find that to be the case.
Okay.
We had 26 cases in the 3 years that we looked at. In 18 cases, the tribunal agreed with the commissioner. In 2 cases, the FTT was more open than the commissioner. It ordered disclosure of more information. In 4 cases, they were more restrictive. In other words, they would have satisfied Lord O'Donnell, although in one of those, that was the result of the intervention of the upper tribunal. Yeah. So, in general, based on that sample, I wouldn't say that the first-tier tribunal was more likely to overturn the commissioner in favour of disclosure. At all, I think there was quite a high degree of sympathy between the two. If anything, they were more likely to be sympathetic to the public authority.
What about the general question, though, about the sort of this charge about uncertainty versus whether there really has been any damage from the release of the information? I mean, is Whitehall, sort of chasing a ghost here? Really?
Yes. In our submission, we said we think that ministers and senior officials have probably got a distorted view because they're dealing with a distillate of the most difficult and troublesome cases that come along. I thought Lord O'Donnell perfectly illustrated that last week. When Lord Howard pressed him for an example of the chilling effect, he came up with the meeting between the coalition partners, where he was asked, is this FOI-able? And he said, I can't guarantee you that it won't be disclosed. And so they met without an official present. 3 days after that meeting, an FOI request was received for the minutes of the meeting and any briefings that officials had produced to inform the meeting or for whatever subsequent purpose. I should say it took 72 working days for the Cabinet Office to respond to that request, by the way. Working days. I invite you to imagine how many working days it took the Cabinet Office to decide they thought there was no public interest, it was not in the public interest to disclose it. I think it would be a matter of seconds, if not minutes, at the outset. So that's just by the way. It finally went, and I think it may be worth looking at why it takes the Cabinet Office so long and what it says about the Cabinet Office is now in charge of this whole process to be responding to FOI in this spirit. It went to the Commissioner, and the Commissioner said, at this critical point in the formation of a government, political parties must have the greatest possible confidence in relying on the services and support of the civil service without any concern that information provided, consulted or relied on may be compromised by being revealed at a later date. They said 36 is engaged, the balance of public interest comes clearly down against disclosure. Now, Lord O'Donnell has used this example not only here, but also to the Post-Legislative Scrutiny Committee. And, there is a point at which he's got to recognise, I think, and perhaps Whitehall's got to recognise, that although he may legitimately have had that question at the time he was asked, it was answered by the Commissioner's decision in that case. The Commissioner's decision did what he would have hoped to do, and I don't believe the tribunal would have come to a different decision, because on all the very sensitive cases that we've reviewed, The tribunal has said you don't have a conversation between a Chancellor and the former Chancellor about a current policy disclosed. This is absolutely in that line of case.
Was that appeals?
Sorry?
Did that decision on the coalition discussions go to appeal?
No, it didn't go to appeal.
Okay.
It didn't. But I mean, I'm saying I very much doubt that that's a case in which, I mean, Lord O'Donnell ended by saying, once it goes into the FOI process, no one has any idea how it's going to come out, as if it's a throw of the dice. You might as well throw a dice as an attempt to predict it. I don't believe that is at all the case. I think, you know, when you have very sensitive political discussions, when you have very frank exchanges, where you have stuff that's going to be very damaging to the official's position if disclosed, where you have splits between ministers, it is predictable.
But Lord O'Donnell is not alone in thinking that this is unpredictable. And the question is, how do we reduce this feeling of unpredictability? I mean, is there any drafting to be done in relation to
it's not? I don't think this is a drafting matter. And although Lord O'Donnell is calling for greater clarity, I think the clarity that he wants is to say, for this type of information, this will not normally be disclosed unless A, B, or C is true. Mm-hmm. So he wants a near absolute exemption, except in specified exceptions. That's not clarity, that's a substantial narrowing of the right of access and of the discretion that the Commissioner and Tribunal has to decide on public interest. So, I mean, one can try and provide more clarity, but if you read the Tribunal decisions, you very often see the Tribunal starts by saying, as a result of the previous decisions, these are the key principles we apply here. So you see that they will tend to do that, and you'll tend to find it in the Commissioner's guidance, though, you know, he could possibly, it's possible he might be able to provide it in a clearer way. But I think what Lord O'Donnell is asking for is guidance that is in effect quasi-binding on the Commissioner and Tribunal. And there I agree with what Lord Carlisle said last week, which is there is a big risk in constraining the freedom of the system to respond to the changing public interest. You're better off leaving it open. I don't think the system has come up with factors of public interest which you look at and say, how could that be a serious public interest factor? That's unbelievable. Somebody's taken a leave of their senses. I don't think there's anything of that in the case law that has happened. I think it's all very sound and it's all worked on perfectly reasonable views.
I think I used the example last week of child sexual abuse, of which the perspective has changed dramatically during my working life, from incredulity that it ever happens to trying to find out who did it, where and when, on the assumption there's been a great deal of it. Do you regard that as a decent example of the proposition that actually the concept of public interest evolves just as issues evolve?
Yes, I do. And I think, although you say over your working life, the greatest acceleration of that change has been since the Jimmy Savile case.
Yeah, yeah.
So that's a quite short period.
That's 4 years or something like that. Yeah. 3 years.
Michael?
You say in your evidence that you don't think the government should have the executive override, the veto. Yeah. But Parliament clearly thought that it should.
Yeah.
Do you accept that the decision of the Supreme Court in the Evans case substantially calls the veto into question, creates greater uncertainty about the circumstances in which it can be exercised, and effectively narrows it very significantly?
Yes. I think that, in my view, that's almost indisputable.
Right. So that's a very helpful answer. Thank you very much.
You might want to add to that.
That wasn't what the man from Liberty said. He was trying to suggest it made no difference.
No, well, that's my view, that it does restrict it. I think as you remember, Mr. Troyer, we were always opposed to the idea of the veto in principle. There's a second thing, which is that after the Supreme Court ruling, the Prime Minister and other people put out statements saying this undermines the will of Parliament. Now, we've questioned that, We haven't questioned whether Parliament intended there to be a veto. We questioned whether Parliament intended there to be a veto applying to the tribunal and courts. Now, as the veto was pretty controversial, as it was, with people believing that it applied to the Commissioner. I think they believed it applied to the Commissioner, because there's no reference from a Minister that it applied beyond, that would apply beyond the Commissioner. The Divisional Court made clear it applied to the Supreme Court as well. That, although it's difficult to imagine a Minister actually being prepared to do this, that in theory a Minister could veto a decision of the Supreme Court, subject only to the safeguard of judicial review, possibly on the standard Wednesbury test, that the Minister had a rational alternative view. It may not be a good or the best view, but just a rational one. I don't think Parliament envisaged that. I think Parliament would have exploded if you'd have said to Parliament, the House of Lords, as it then was, can be overturned by a Minister. And all the Minister has to do is say there's something sensible that can be said from my point of view. I don't think they understood that that was the case.
Right. Well, we're not concerned with the hypothetical circumstance of whether the Minister should have the right to overrule the Supreme Court.
No.
Let's take it step by step. On the question of the existence of a veto, there's no doubt that Parliament thought there should be a veto. So in terms of our consideration, when we have to put on one side the clear view of Parliament that there should be a veto, and your view that there shouldn't be, we are obviously bound to give effect to the clear view of Parliament.
I don't understand how you're bound by the view of Parliament. You're here to give your view on policy. I mean, the courts might be bound by the view of Parliament.
To use the language of Yes Minister, it would be very courageous of us to say that Parliament got it all wrong, but Mr Frankel got it right.
But I mean, what could happen to you? Are you going to lose your peerages if you say that?
No. It's a question. It may affect the seriousness with which our report is taken if we were to take that view.
Okay, but I mean, of course, you can take that line if you want to, but you're not obliged to. But I'm not trying to seriously, I'm not going to have a long debate with you about it.
Okay, we're agreed that Parliament expressed the view that there should be a veto. Now, I would suggest to you that Parliament also clearly envisaged, if you look at the terms of the Act, that the veto could be exercised on a decision of the upper tribunal. Because if you look at section 53, which defines the effective date includes the day, and specifically, expressly says, the day on which that appeal or any further appeal arising out of it is determined or withdrawn. So that language clearly demonstrates that Parliament not only wanted there to be a veto, but accepted that there could be a veto on the decision of the upper tribunal.
Well, that's what Lord Neuberger and two other Supreme Court judges didn't accept. They didn't accept that that was crystal clear.
That's what they said.
That's what they said, yes.
But I've put to
you're
you the language...
You're inviting me to say that I think that the Supreme Court was wrong.
Well, if you've said Parliament was wrong, I don't quite see why you shouldn't say the Supreme Court was wrong.
I don't...
Mr Frankel, I don't think he must speak for himself, he always does, Lord Howard, but I don't think he's inviting you to offer a sort of a judgment on the merits, but it is just a fact, is it not, that section 53(4) envisages that the veto can be used on appeal. I mean, that's what the words say.
It envisages it, but the Supreme Court quoted Court of Appeal in other cases. So that's the line of argument. I don't think we're going to settle it here between us.
Okay. So if there is to be a veto, do you have a view, put aside Parliament's view, put aside the Supreme Court's view, do you have a view as to when that veto should be exercised?
Well, we've got two... Professors Forsyth and Evans put two options on the table. One being that one of them, I must say, I didn't quite understand, because I understood them to be saying that you would treat the exercise of the veto as an exercise of discretion by the Commissioner. Sorry, not the veto, the decision on public interest as an exercise of discretion by the Commissioner. Now, I mean, you'll be much better placed to know whether this is right or not, but my understanding is that's not an exercise of discretion. Decision on where the public interest lies is not a matter of discretion, it's a matter of law. It may be one where it's difficult to see very clear boundaries, but it's a matter of law, not discretion. Discretion is if the Commissioner decides to issue an enforcement notice or not to issue an enforcement notice. There's nothing in the Act which tells him that he has to do that. Not a decision notice, an enforcement notice, which can be used in other circumstances. So I don't think, if I understood what the professors were saying correctly, just question that bit of it. It seems to me we've got several different options. We've got the Commissioner's suggestion that there be some kind of prospective veto in relation to a decision which is in support of his decision anyway, in case it should be overturned at a later stage. You've got the Policy Exchange pamphlet author's suggestion that you cut off the right of appeal on public interest grounds once it gets to the Commissioner's stage and don't go beyond it. I think that would be the worst of all possible worlds myself. I mean, maybe constitutionally neat, but it undermines the Act very substantially. I think you have another option, which is to apply a stricter standard to the use of the veto as you go up the chain. It doesn't necessarily have to be in exactly the terms that either of the two groups of judges in the Supreme Court put it. In other words, it doesn't have to be as restrictive as Lord Neuberger put it, but you could go up the but I think there was, but it seems to me there was a valid point in saying that, the Act says the Minister on reasonable grounds believes that the decision was wrong, and effectively the issue that concerned the courts all the way through is, does reasonable grounds have the same meaning at every stage of the appeal? And it seems to me that they obviously decided that something that might be reasonable in relation to the Commissioner would not be reasonable in relation to the Court of Appeal or the Supreme Court, which I think in common sense terms has something for it. So the alternative way is to have a stricter set of tests the higher up you go. You don't have to put Lord Neuberger's formulation into statute to do that. You can come up with a different formulation.
But you mentioned, without expressing a view on it, the Commissioner's view that there should be the provision not only for a veto of an adverse decision by him, but also a kind of confirmatory veto of his decision. And you identified that, but you didn't express a view on it. What do you think about that? And then an appeal from that on judicial review terms or point of law to the upper tribunal.
Well, I agree with what Dominic Grieve said about that, which is that the full implications of that decision, it's not so much the full implications, the government may believe that it's indisputably right in saying if that decision goes further, we're going to veto it. But it's possible the tribunal at some stage may say something which casts new light on the issue, which changes their minds. And it's a factor of the tribunal process that, because they are putting decisions under closer scrutiny than the Commissioner can do, with counsel present, with written evidence present, with witnesses present, a decision acquires new dimensions that could not have been apparent to the Commissioner. Very often there's new information discovered that was not recognised at the time it went before the Commissioner, bypasses the Commissioner, appears on the scene at the first tier stage. So I think I'm attracted by that if there's a way of doing it.
I apologise for going back half a step, please forgive me. I just want to be clear about the difference between yourself and the duo of professors who gave evidence earlier.
Yeah.
They appear to be saying that the Commissioner exercises a discretion.
Yeah.
What you're saying is it, that under Section 50, the Commissioner is obliged to make a decision.
Yeah.
Therefore, it's unarguable that he's exercising a discretion because he's obliged to make a decision, and that the decision has to be made on legally tenable grounds, so that turning it into a discretion would be a fundamental change in the law. Is that a fair summary?
Yes, I mean, well, my understanding is not that when the Commissioner makes a ruling on the public interest, he's not exercising his discretion.
Okay, just so I understand the difference. Yeah, that's clear.
I'm now moving away from questions on the veto, so if any of my colleagues have any further questions on the veto, this would be the moment to ask them. Right. So, in relation to the length of the process, you've suggested that there should be no extra time for the public interest test except where some external consideration is involved. Do you want to elaborate on that in any way?
Well, the environmental information regulations provide a model for that. They allow a further period of 20 working days or 1 month on the grounds of the volume and complexity of the information. Well, there are other ways of putting it. See, I don't believe the need for extra time is to do with the public interest. It's to do with complex cases or the need to consult third parties in reality. And just as I suggested with the case Lord O'Donnell mentioned, the idea that the Cabinet Office needed 20 days to think about whether this... Sorry? The idea that the Cabinet Office needed 20 working days to decide whether this fell within Section 35 or 36, and then some longer period to think about the public interest is absurd. Obviously, they must have reached their decision the moment they addressed their minds to it. The only circumstance in which they would need more time is if they really had to go and consult externally, or perhaps even internally, or if there was just a giant pile of material that had to be looked through and there were different considerations on every page. But in general, you don't need extra time. And we raised this with officials while the FOI bill was going through, and the officials agreed that the volume and complexity would be a better approach. If I'm not disclosing policy advice here, but they said it's just not, well, they agreed with me, this is not a ministerial communication, but they said it's not worth trying to unstitch anything now because the whole package will fall apart if we try and do it. That just gives public authorities some extra time. It's not actually needed for public interest reasons. And in terms of streamlining the process, do you see any attractions in the Scottish system? Whereby you don't have the first-tier tribunal, so you just go straight to the upper tribunal? No, I don't. You don't? I don't. The Scottish, first of all, the Scottish system draws on the decisions of the first-tier tribunal here. The UK system does provide them with some guidance. They're not binding precedents, but they draw on them when they find them helpful. Secondly, the Scottish system was set up from scratch, and they employed people at a level and paid them at a level that they needed to take those decisions. The UK system built on the existing commissioner structure, which were people doing decisions purely on data protection, never published, never subject to scrutiny, no right of appeal to the tribunal, which was there but was not available to the requester. I don't think their decisions are, although they've improved very substantially, they're not at a level where I'd be very happy. No, here. To say we can do away with the first-tier tribunal and just have occasional, on a point of law, appeals. I think sometimes the Commissioner's decisions get it wrong, and I'd be sorry to see. And if you look at the statistics on appeals to the first-tier tribunal, I think the figure is 17% of requester appeals. This was over a period of January 2014 to March 2015. 17% of requester appeals were fully or partly upheld or resulted in a consent order, which I think is at least involves partly upheld by agreement. That's a reasonable, I mean, it's not a massive number, but it's a reasonable number to suggest that the first-tier tribunal are providing a useful function in relation to requesters' appeals.
Were any of the 17% reversed by the upper tribunal?
They don't list them, they just give me the numbers, so I can't tell.
That would be a relevant
it would, but it's a very small number that have been reversed by the
On this streamlining, could I just raise two other points? One is what is your view now about the role of the internal review Is that necessary, or should this not be got right first time with the right kind of escalation within the department? And secondly, the role of the qualified person in Section 36 seems to me to be a hangover from an earlier draft of the bill, and it's causing a lot of public authorities, clearly local authorities, etc., quite a lot of problem, as we heard this morning, of a decision being taken at one level and having to then be reviewed by somebody at a different level in the organisation.
On internal review, I always thought there were two possible justifications for it. The first is that it led the decisions by the time they went to the Commissioner to be much more fully argued and set out. So they simplified the Commissioner's decision by making sure that the requester's arguments were heard once, and so that made it easier for the Commissioner. The other argument was that 25% of cases, some benefit to the request, the request was upheld. But as I thought about it, it occurred to me that I'd never seen a case where, not that I see that often, the actual correspondence, where the internal review says we were wrong to say this should be withheld. It's more often we agree that we didn't comply in 20 working days. Now, if that's the case, then if most of those cases which uphold the request of an internal review are just saying, you're right, we took more than 20 working days, there's no point. Now, I recently, in connection with the Lansley Diaries case, I made an FOI request to the Department of Health for the cost of taking that case as far as it's gone so far, which is first tier, upper tier, and permission to appeal to the Court of Appeal. Because I think that basically the argument that's being run is that largely the argument that if ministers have empty spaces in their diaries, that's revealed, they will schedule unnecessary meetings. Well, both the first tier and the upper tribunal have said that's ridiculous, that's absurd, and I've no doubt the Court of Appeal will say that's absurd as well. So how much money has been spent trying to promote that argument? And the Department of Health, and this was not the Department of Health on its own, because I think they're a proxy for the Cabinet Office here, said it's in the this was their answer. We're going to publish that when the case is finally over. It's in the public interest. It should be published when it's finally over. Therefore, it's the total cost of external legal advice. Right. This can be ascertained from 3 or 4 invoices that they've had from the external lawyers. So it couldn't be less work. There's no complexity. There's no complex statistical series that will be interrupted. So all they said, and the test is that it's reasonable to withhold it until the date of publication, and the balance of public interest favours withholding it. All they said was, it's in the public interest that it should be published when it's all over. They didn't say why it wasn't in the public interest to publish it now. I asked for internal review. They simply repeated exactly the previous argument without addressing the shortcomings that I pointed out to them about their argument. I went to the Commissioner, and as a result of the Commissioner coming on the scene, Department of Health / Cabinet Office decided to release the information. Internal review played no part at all, and the cost, by the way, is over £30,000. The cost of the Better Regulation Committee appeals, which have gone to the first tier, upper tribunal, and back to the first tier, that decision, I guess, I haven't asked for it, is £20,000 to £25,000. And the information that they've spent that money on is the figure 13. There have been 13 meetings. That's cost the public purse £20,000 or £25,000 to stop us knowing that, which they've now told us. What's the point of spending that kind of money? I can't remember how I got here. The qualified person, I think, may be a hangover from the time when Section 36 was perceived as a quasi-veto for public authorities other than government, central government, and that they thought that once the qualified person engaged the exemption, the chances of a decision on public interest were minimal, on public interest grounds were minimal. That's not proved to be the case. In Scotland, there's no qualified person. It works in the same way as any other exemption. I think you possibly could get away with that here without bringing the House down. But if you do that, you might as well remove the reasonable opinion at the same time and make it a straightforward exemption, prejudice the effective conduct of public affairs, and it's testable in the same way.
Could I just ask you this about on the qualified person? One argument we've had is if you remove the qualified person test, then public authorities would be engaging Section 36 more frequently.
Yeah, they would.
So you'd have more information refused publication.
Yes.
So isn't that a danger?
That is the danger. That is the danger, and that's what you would have to look at. I mean, the point is that it's a catch-all. It just says any other harmful effect on public affairs. It's not limited in any way, and that is the danger.
Now, you've already told us that you think that the Act should apply to charities when they're acting as contractors to public authorities.
Yeah.
What about the extension of the coverage of the Act to charities more generally?
That is a difficult question for us. We've discussed that, and it's one of those where we would want to actually go and talk to a lot of people ourselves before we decide on it, because it's got a lot of implications.
Are you a charity?
No. We don't have any problem. If somebody said to us, you should be subject to the Freedom of Information Act, I'd say, well, since we demand that everybody else should be, yes, of course, we should as well. So I don't have any problem about our own status whatsoever. You know, I mean, I happily go along with whatever the position is. We get money from charitable foundations for work we do which is charitable in nature, but we are not a charity ourselves. But it's a large question. It's not the kind of question that we would try and answer off the top of our heads. Public schools are charities. You have the giant charities who are involved in the call centre problems, which I must say, makes everybody feel that the more scrutiny, the better. You have small charities who are campaigning organisations where a right of access applying to them and not to the organisations who are campaigning against their views might create an imbalance. So I just don't know the answer to that question. It's not that I don't want to answer it. I don't want to answer it off the top of my head.
Right. No, thank you. And we've heard, and you've heard, numerous requests for an extension of the vexatious requests provision.
Yeah.
What's your view on that?
My view is that public authority had quite a substantial extension of that term now as a result of the case that's gone through the upper tribunal and the Court of Appeal, so that requests can now be refused on the grounds of burden alone, even if there was no sense in which the requester was behaving vexatiously. In other words, I might ask completely innocently for information on a particular subject without realising there's a filing cabinet worth of stuff there. And under this decision, that request can be treated as vexatious. Well, that's a harsh term to apply to a request made in that context, but it does give the authority the protection it's looking for from having to do a lot of work.
Can't it be rebadged?
It can be rebadged, and that might be the solution.
Because the case you've referred to doesn't protect the authority for what might be regarded as frivolous requests. The burden test helps in one sense, but there are other complaints about requests which ought to be treated as vexatious, but don't really come within the terms of the legislation as currently drafted.
I think they probably do now, because the Commissioner's guidance in response to the upper tribunal decision was to say to authorities, in any case where you feel that a request is a disproportionate, involves a disproportionate burden or disruption or distress or harassment or whatever it is, not justified by the value of the information. That is the test. Right. I mean, to be honest, if somebody said, can you... I mean, how many people called David?
Yes.
It's not worth it. I think, as Kent County Council said, the work involved, it's retrievable fairly easily, so you may not bother about it.
They had another case where it wasn't quite so easy.
No, but if it is actually laborious to retrieve that, and it's 12 or 14 hours, and no one can see any conceivable purpose for it, you might say, unless you can I'm inclined to the view that this is vexatious in the sense that, and there's no serious purpose to it. And unless you persuade me otherwise, that's how I'm going to decide, you say to the requester. I think you probably can, that's probably stand-upable now.
And what about the cost of necessary redaction and taking that into account in the cost calculation?
The problem with the cost limit at the moment is it's an absolute ceiling. Yeah. It makes no allowance for public interest of any kind. So there are all kinds of tweaks that authorities are calling for in order to take more things into account. I thought, by the way, the NHS providers came up their solution, which was to turn it into an 8 hours or 1 day's work plus consideration time and redaction time, would kill FOI altogether, by the way, because it's one thing to say one person spends a day looking at it, but very often you have 3 officers and 3 people have to look, and if you have consideration time as well, you will find very few requests have to be answered.
I think Lord Howard's question was
just redaction.
Just redaction.
And those redactions which are required by law, I mean, which would basically be, personal information, and those things to do with commercial and confidence, and maybe combined with accepting that this limit should go up over time, as most other...
I don't make any distinction between redaction required by law or redaction of other exempt information. It's going to
I don't
cause
know,
harm.
I meant exempt.
It's going to cause harm.
Sorry, I was categorising exempt information as
yeah.
being required by law.
Because Section 40, you might argue, is required by law.
Yes.
Obviously, that's a workload. The question is this. If you have an inflexible level and a large document, is the introduction of redaction time without a provision for expanding the cost limit to, in case this is a really serious issue, is that going to cause a restriction beyond what is justified by the workload? And I think it may do in some cases.
So what you're really suggesting, although you haven't quite articulated it, is that if you could have a provision which said you can take into account redaction time as a factor in deciding whether or not the information should be disclosed, but not as an absolute exemption.
Yes, I mean, the new definition of vexatious is primarily based on redaction time.
Yes.
That is actually what it takes account of mainly.
Yeah.
But if you want to take it into account for
those commercial things, we've had many examples that have been given of some of these commercial requests for IT contracts, etc., which, seems to me, would very often the thing that causes the problem for the authority is the redactions that are involved in those things.
Well, I'm not sure whether it is the redaction. When you were asking for the IT information, there's usually no redaction. I know what County Council said. I don't think there's usually any redaction. It's the pain of collecting the information where they think they don't see a public interest in the release of the information. Can I just say on this that the issue of how much time authorities take came up on a mailing list that authorities subscribe to, which is open to outsiders as well, 3 years ago. And all the authorities were asked how many requests they get and how many exceed the 20 days. And one authority said, we get 520 requests a year, and it takes me, and I'm the person who deals with it, 1 day a week to deal with them all. And this is one of many jobs that I have. And the universe collapsed on this, people. All the other FOI officers said, you're trying to put us out of... How do you manage to do that? It's Barrow-in-Furness Council. And I went and looked at their requests on what do they know, and they seem to be no less complex than anybody else's. I spoke to the FOI officer on Friday in anticipation of this. And they do it because the FOI officer has been replaced by somebody else, but still the same thing, has been there a long time, is trusted to take decisions herself, and knows what goes on in her authority, and doesn't have to go up isn't a junior person who can't take a decision go up the chain. And that's how they do it. It's a matter of the process and experience they have. And in 2013 they had 556 requests, and in 2014 they had 748. Went up by 35%. The following year it went down to 594%. How did you do that, I said to her. She said, we studied all the requests that we'd had, and we decided to publish as much of that possible as a data set. And that's what's brought it down. The police, when they came here, said, well, you can publish more information, it doesn't help. But I suspect they're publishing the wrong information. I don't think they're looking at what the requests are. they're getting requests for what software they're using, and when their contracts come up for renewal, that's what they should publish. But what they're doing, and Parliament did this with the publication schemes, we publish Hansard. Parliament put Hansard in its publication scheme when this provision was introduced, so it's been published for 200 years. They were just listing the things they were already doing without extending them.
Could I just going back briefly to the issue of the veto, Mr. Frankel, because you said a moment ago, in a different context, quotes the whole package would fall apart. I acknowledge, it's a matter of record, that your campaign, and you were to put it at its mildest, were not keen on the veto when it came up in the year 2000. But would you accept that the veto was an essential part of a balanced package which government put forward to secure a broad consensus on the freedom of information issue after a lot of controversy, and that was, as it were, balancing the power that was given to the Commissioner to make otherwise binding decisions?
Well, I accept that you put it forward as a quid pro quo, and that was what persuaded you and the government to make that concession in terms of making the public interest test legally binding. So in that sense, yes, I do accept it. But I just want to point out about our veto, that there is no veto. If the Ministry of Defence says the disclosure of this information is harmful to defence, and the Commissioner says no, it isn't, there is no veto.
No.
And the same for foreign relations, and the same for law enforcement. It is a particular aspect of how...
Sure, I understand that. But it's also fair to say, isn't it, that right at the end of the process, the Campaign for Freedom of Information was sufficiently happy about the outcome that they made awards which may now appear to be eccentric to those who've been responsible for the act.
We were concerned about it, actually. We were concerned the veto would be used very heavily. It hasn't been used very heavily, which I think has been a relief to us, and I think it has strengthened the act that it hasn't been used so heavily.
Mr. Frank, my last question is a roll-up question, which I hope I won't regret asking. But first of all, are there any things in your view which fall within our terms of reference where we could improve transparency in the operation of the Act? And secondly, is there any comment you want to make on the evidence you've heard, which you haven't already made during the course of your evidence this afternoon?
I hope you're not going to regret this, I don't think, because I'm going to be very brief. I think the role of the Cabinet Office in being such a reluctant participant in FOI, and its view that every individual decision is a precedent when that is not the case, I think in terms of change that's needed, change is needed in that area, in that department, in its central coordinating influence over the whole of government. That's what I think is particularly needed. There are other specific changes, like the Justice Committee recommended a change to the time limit on the shredding offence, which hasn't been implemented. I think that is overdue and would be useful.
So, comment on other evidence that you...
I've deliberately tried not to comment on everything that I wanted to comment about, because otherwise we'd take up another hour.
Okay. Well, if you feel like writing in response to it, don't hesitate. I have one final question, which is one I kept putting to people during the course of these sessions, which is, I am very surprised to discover that many public authorities do not publish the answers that they give on FOI, which has always seemed to me to be a way of diffusing some of this. And why should the information not be made generally available? That basically there seems to be a tendency to give requesters information for them alone, unless they happen to be on public web through other means. And do you have a view about this and the disclosure logs?
I think I completely agree with you. I think it's perverse of authorities to go to the trouble of vetting the information for disclosure and releasing it to somebody who may put it in their drawer and never make any use of it. Put it on the website, it does the authority's reputation a lot of good, and it's available for anybody who wants to see it. in circumstances which may not even be anticipated at the time it's been requested.
Okay, well, thank you very much. And again, thank you so much for your evidence. It's been very helpful and important. And for sitting through all of, joining us sitting through all of the sessions. Thank you very much.